After a year or two, or even more abroad, you find that not only have you gained some incredible experience, but you've also fallen in love and gained a partner or spouse from your new home. The two of you have decided to return to Canada, and now comes the fun part. Assuming that your new partner is a foreign national to Canada, you will now need to deal with a complex and potentially confusing Canadian immigration process. In this series, we ask one of Canada's most respected immigration lawyers some of the questions that are often on people's minds. It gives me great pleasure to welcome Marina Sedai. Marina's firm, Sedai Law, is based out of Surrey, BC. She has been practicing immigration law exclusively since 2005 and is a past national chair of the Canadian Bar Association's immigration section. She joins me in this series answering questions about the process of bringing a foreign national partner or spouse back to Canada. Marina, thank you once again for joining us for our third installment in this series.
Thank you for having me back.
Marina, I'm curious about, can a couple complete an application process before coming to Canada so that the foreign national spouse or partner can gain permanent resident status?
Yes, there's two streams, two processing streams. One is known as the outside of Canada stream. And that one, it doesn't matter where the foreign national is, just as long as wherever they are legally there. And then the other one is the spouse or common law partner in Canada class. So most people shorten that to the inside of Canada stream. And that, in that case, they do care where the applicant is. The foreign national must be living in Canada, cohabiting with their Canadian sponsor. So for couples who want to come to Canada and get the application process going before they get here, they can only apply in that outside of Canada process.
Okay. So what if a couple wants to enter Canada while the application process is ongoing?
Right. So that's quite common. And it really depends. So there is arguably, in my view, somewhat of an unfair divide in this world, but the government does have some good reasons for imposing visas on foreign nationals of certain countries. Typically, there's a history of foreign nationals of those countries staying beyond the validity of their temporary residence in Canada. That there have been a lot of refugee claims from that country. So for foreign nationals who are visa required, it's going to be tough to come to Canada unless they have a very good history of travel. They're really a good candidate for that visa. Maybe they already have a visa to come to Canada and they have visits before, so they can use that visa. But the reality is that usually visa officers refuse the applications for those visa required spouses, which is quite unfortunate. Not as much of a tragedy now that the processing time is down to 12 months, or 80% of applications are processed in 12 months, so the less complicated ones. So the couple can wait outside of Canada, or there might be a separation for a while until that foreign national spouse can come to Canada because their permanent residence application has been approved. But for spouses or partners, foreign nationals who are not visa required, so that's the typical Western countries, Australia, Britain, etc., the United States, that coming to Canada is usually a fairly straightforward process. They have to be careful, though, about their intention. Sometimes people innocently will say that, misstate their intention. They say, I have permanent intent, because they're thinking, I'm going to apply for permanent residence and my hope is that I get to stay in Canada. Well, if they say they only have permanent intent, they're telling the officer that they will do anything to stay here, including be here illegally. So it's very important to get advice on how to properly express their genuine intent to be compliant with the law And if they need to leave Canada, they will. But if their permanent residence application is approved, then they will stay permanently. So the other, what we want to look at in that case as well is if they're trying to come to Canada at some time during processing, we need to consider that, do they need to work? And sometimes that's fairly straightforward. They have an employer in Canada that can separately, unrelated to their family class case, help them get a work permit. And at other times, they don't have that. They want to get here and look for work, and they don't want to be waiting months and months before they have an income. In that case, it can be a little bit tricky because the outside of Canada stream does not bring with it automatically an open work permit that the inside of Canada stream has.
Very good. Marina, once again, thank you very much for joining us.
My pleasure. Thank you.
And thank you for watching. If your questions are a bit more specific or perhaps complex, Sedai Law would love to hear from you. They're there to help. Make sure that you mention that you watched this episode. Their contact info is in the description. This is a series about immigration and is published every Thursday. Make sure that you like this video and subscribe so that you don't miss out on any episodes. Until next time.